Today I'm going to read Article 1, Section 8 of our beloved Constitution for the United States of America.
Everybody needs to get this book. Barnes & Noble, $3. Learn your rights.
Section 8 of Article 1. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts, and excises shall be uniform throughout the states. To borrow money, without defining the definition of money in the sentence, to borrow money on the credit of the United States, to regulate commerce with foreign nations and among the several states and within Indian tribes. Absolutely not. It is not their right to give.
So, Congress has the right to declare war. How about if Congress gave the right to declare war to Halliburton? Would that be a good thing?
Okay. Perhaps, but to coin money, again, Article 1, Section 8, as you were saying, says the words are to coin money, regulate the value thereof, and of foreign coin, and fix the standard of weights and measures. Also, to provide for the punishment of counterfeiting the securities and current coin of the United States. Moving on to Article 1, Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin, and tender in payment of debts.
That's the winner right there. Make anything but
gold and
silver coin legal tender. Now, legal tender means that you can pay your debt with it. If I demand to be paid in legal tender, I demand to have my debt paid. Only gold and silver can pay a debt.
And one of the biggest frauds being exuded upon us is when we get hauled into a court and told to pay a fine in
anything other than
gold and silver. We get told to pay in Federal Reserve notes.
And the Federal Reserve was founded in 1913 and was given the authority by Congress to print money, to create money from thin air, an elastic form of money. What's elastic? How elastic is gold? Can you stretch it out and make more of it? Can you duplicate it? No. So the Federal Reserve is an unconstitutional organization that controls our life. And today's show, we are going to discuss the foreclosure issue. You have remedy if you are being foreclosed on by the bank. And we're going to explain some of that remedy and how a foreclosure works. So, Dave, will you talk about the Credit River decision?
Of course, sir. And also to mention the Federal Reserve being a private company, the same as the IRS, these organizations are corporations and cannot make law nor enforce it. So they're not part of the federal government. Anyway, so on to the Credit River decision. State of Minnesota Injustice Court, County of Scott, Township of Credit River. Martin versus Mahoney, Justice First Bank of Montgomery. Plaintiff, case number 19144 versus Judgment and Decree, Jerome Daly, defendant. The above entitled action came on before the court and a jury of 12 on December 7th. 1968 at 10 a.m., plaintiff appeared by its president, Lawrence V. Morgan, and was represented by its counsel, Theodore R. Melby. Defendant appeared on his own behalf. A jury of talisman were called. Lawrence versus Morgan was the only witness called for plaintiff, and defendant testified as the only witness in his own behalf. Plaintiff brought this as a common law action for the recovery of the possession of Lot 19, Fairview Beach, Scott County, Minnesota. Plaintiff claimed titled to the recovery of the real property in question by foreclosure of a note and mortgage deed dated May 8, 1964, which plaintiff claimed was in default at the time foreclosure proceedings were started. Defendant appeared and answered that the plaintiff created the money and credit upon its own books by bookkeeping entry as the legal failure of consideration for the mortgage deed, and alleged that the sheriff's sale passed no title to plaintiff. The issues tried to the jury were whether there was a lawful consideration and whether defendant had waived his rights to complain about the consideration having paid on the note for almost 3 years. Mr. Morgan admitted that all of the money of credit which was used as a consideration was created upon their books, that this was standard banking practice exercised by their bank in combination with the Federal Reserve Bank of Minneapolis, another private bank. Further, that he knew of no United States statute of law that gave the plaintiff the authority to do this. Plaintiff further claimed that defendant, by using the ledger book, created credit and by paying on the note and mortgage waived any right to complain about the consideration, and that defendant was stopped from doing so at 12:15 on December 7th, 1968. The jury returned a unanimous verdict for the defendant. Now therefore, by virtue of the authority vested in me pursuant to the Declaration of Independence, the Northwest Ordinance of 1787, the Constitution of the United States, and the Constitution and laws of the state of Minnesota, not inconsistent therewith, it is hereby ordered, adjudged, and decreed that plaintiff is not entitled to recover the possession of Lot 19, Fairview Beach, Scott County, Minnesota, according to the plat thereof, on file in the Register of Deeds office. That because of failure of a lawful consideration, the note and mortgage dated May 8, 1964, are null and void, that the sheriff's sale of the title or interest in said premises or lien thereon, as is above described, that any provision in the Minnesota Constitution and any Minnesota statute limiting the jurisdiction of this court is repugnant to the Constitution of the United States and to the Bill of Rights of Minnesota Constitution, and is null and void, and that this court has jurisdiction to render complete justice in this cause, that defendant is awarded cost in the sum of $75, and execution is hereby issued thereof. A 10-day stay is granted. The following memorandum and any supplemental memorandum made and filed by this court in support of his judgment is hereby made a part thereof by reference. By the court dated December 9, 1969, Martin v. Mahoney. The issues in this case were simple. There was no material dispute on the facts for the jury to resolve. Plaintiff admitted that it, in combination with the Federal Reserve Bank of Minneapolis, which are for all practical purposes, because of their interlocking activity and practices, and both being banking institutions incorporated under the laws of the United States, are in the law to be treated as one and the same bank, did create the entire $14,000 in money or credit upon its own books by bookkeeping entry.
That means they just put it in there.
Yep.
It doesn't exist. They didn't deposit any Federal Reserve notes into an account. They just entered it on the computer screen or wrote it down on a piece of paper.
Nothing tangible, not even paper, except the paper and ink that they were using to enter into their ledger. That this was the consideration used to support the note dated May 8, 1964, and the mortgage of the same date. The money and credit first came into existence when they credited it. Mr. Morgan admitted that no United States law or statute existed, which gave him the right to do this.